Hi there, this is Jonathan Ginsberg. I'm a personal bankruptcy attorney here in the Atlanta area, and I'd like to answer a question I get from my Chapter 13 clients frequently, and that is, what's the likelihood I'm going to have an objection to my Chapter 13 case? Is the trustee or creditors going to object to the confirmation of my case? Am I going to lose my Chapter 13 and have to start all over again? Well, the answer to the question is yes, there are going to be objections. I would say in Chapter 13, it's almost guaranteed. 100% of the time, there are objections to confirmation. And people get these objections, they get really worried because the objection says, comes now the creditor, comes now the trustee, objects to the confirmation of the Chapter 13 plan, and asks this court to dismiss the case. Well, first of all, getting the objection does not mean your case is dismissed. It simply means we have a problem to fix. And normally, we're going to have about a month or even 6 weeks to get that problem fixed because the confirmation or formal approval of your Chapter 13 takes place about a month after the 341 meeting of creditors hearing. So we have some time, although when you get that objection, the first thing you need to do is get on the phone, email your attorney, let me know immediately so we can start working on it. Now, the reason why we have so many objections is that Chapter 13 cases are complex. And realize we're talking about a 5-year plan. When I prepare Chapter 13, I will go in as a zealous advocate for my client aggressively. I will propose a plan that pays as little as possible to creditors at the lowest possible rate. Creditors and the trustee, on the other hand, are going to come back and say, we want more money. We want a higher trustee payment. We want a higher percentage to unsecured creditors. We want a higher total payment. And really, we'll work something out in the middle. And this is sort of the way it just works in terms of negotiating a Chapter 13 figure that everybody can live with. We go in aggressively, they go in aggressively, and we settle someplace in the middle. Now, some objections are going to be pretty common, and these are things that can be fixed fairly easily. Things like funding. You haven't made all the trustee payments. Well, again, you've got to make the payments. The employer deduction order kicks in, takes care of that. There could be a terms problem. The case is running too long. It's running 65 months instead of 60. So we either reduce the percentage to unsecured creditors or we increase the payment. There could be an adequate protection objection where a creditor says we're not getting enough money every month. We want more allocated to us as part of the Chapter 13 plan each month. So there are a lot of different types of objections. Most cases have 5 or 6. Sometimes I see 15 or 20. But as long as I can start working on them early, I can get them all fixed. And the end result is I get all the objections withdrawn prior to the confirmation hearing. We don't have to go, you don't have to go, I don't have to go. The case gets confirmed, and you're on the road to getting that Chapter 13 discharge. So big picture, if you get an objection, when you get an objection to your Chapter 13 plan, don't freak out, don't worry about it. Call your attorney, realize that this is very common. We'll have plenty of time to get these things fixed, and in almost every case there is a fix for whatever objection is filed. So hope this has been helpful. Again, I'm Jonathan Ginsberg. Please give this a thumbs up on YouTube or a like on Facebook, and subscribe to our YouTube channel, like us on Facebook, our Facebook page. If you have any questions or thoughts about future videos, please let me know that as well. So again, Jonathan Ginsberg here, and thank you very much.